I'm Gary Venner, CEO of IFA Acquisitions, and I'm joined by Glyn, insolvency practitioner and partner of national business advisory firm FRP Advisory, where we continue our informative question and answer series on our YouTube channel to provide top tips when selling an IFA business and an insight into market conditions faced by company owners that are looking to exit and liquidate. The title of this video is coming up on our screen now. So from a business owner, what can they do to achieve an efficient and quick winding up of their business?
Right, as I said from the in our earlier session, one of the keys is in that pre-solvency work, the pre-liquidation work, making sure that ultimately when the business comes to the liquidator, it's been deregulated, all assets have been turned into cash where possible.
Yeah.
Good quality accounts have been provided to HMRC and all tax liabilities have been properly identified. The company's been deregistered for VAT and PAYE wherever possible. And what I'm getting is just simply a shell of a limited company with its assets, no liabilities, and my role is simply to distribute the money to the shareholders. And I can normally achieve 90% of that distribution within the first 28 days. And then the remainder 10%, we have to wait until we've got tax clearance from HMRC, which can take between 6 to 9 months.
Sure. Are there any other pitfalls to watch out for as well?
Every case is going to be individual. And what I've just described there is almost your vanilla members voluntary liquidation.
Right.
Right from the outset, the key is for the insolvency practitioner to fully understand the business, fully understand the regulatory framework in which it operates, liaise with the FCA to identify any potential pitfalls that may exist. I would say from experience, some areas that have caused problems and have delayed a liquidation would be where we haven't had shareholder consent to the process. So some shareholders aren't necessarily happy. If there is a director that's not prepared to swear the declaration of solvency, issues like that. And that's why it's very important to get them ironed out at the earliest juncture. There are kind of a plethora of other things that can cause delays. And part of that initial kind of role, as I said, that I have, is just making sure I identify those and then just get those problems solved.
Yeah, and they're almost, you don't think they're going to happen, but when you've just been mentioning that, I can think of instances when, oh yes, that's happened in the past as well.
Yeah.
So
another example, really simple one, registration of a charge, a debenture against a company, still marked as outstanding. We've got to get that marked as satisfied before we can go through the liquidation process. But that would be readily identifiable by me at that first meeting.
Yes.
And I could correctly signpost that as to what needs to be done. So I always like to think that everything is solvable. It's just about that initial meeting, highlighting, having the wind down plan and making sure that everybody's in agreement with that. All those stakeholders in the business are in agreement.
Sounds fantastic. So once a liquidator is actually appointed, Glyn, will the director's powers cease from running that business at that point?
For the solvent liquidation and the insolvent liquidation, yes. All powers as a director cease and they can no longer bind the company going forward. Now, within a member's voluntary liquidation, is unusual, but it can be the case that we can extend the director's powers at the general meeting if there were certain things that needed to be dealt with. If there were certain assets potentially that needed to be sold, a property, we could potentially extend their powers to execute that, so long as, again, we had shareholder approval, which you'd obviously obtain at the general meeting.
Sure. And can closing down the company affect the shareholder from owning other businesses in the future?
No. Closing down of a company and liquidation doesn't affect the shareholders. In the sense that the solvent liquidation, obviously they get their money out. If it's an insolvent liquidation, they've lost their investment. If a director is a slightly different story. A solvent liquidation shouldn't have any impact on the director whatsoever. An insolvent liquidation can have an impact on the director. A director can be disqualified from acting as a director in the future, and they can be fined if they've conducted themselves in an inappropriate manner. But again, that early meeting that we have should identify concerns like that.
So Glyn, for many of our the share purchase deals that we broker, for often the acquirer, will buy that company and they'll go and meet with the clients and do a good handover with the vendor and get the clients to sign new fee agreements in the acquirer's company, leaving a sort of company then that has no clients. How easy is it for the acquirer to liquidate that company in that situation?
In practice, it's possibly in the best position it can be to be liquidated, and it should be quite straightforward. Sometimes the reality is a little bit different, but if we think about it, all the hard work has been done. The liaison with the FCA would have taken place. They would be aware of the sale of the client book. The harm to clients should have been taken out of the equation, and they'll be comfortable that the right signposting has taken place to ensure that the clients know exactly what's gone on. And by reason of the fact that they've have been repapered, that should further evidence that. So really, at that point in time, I'm getting that limited company with simply assets to distribute. And so long as we've then got the good quality management accounts, that we can get the corporation tax liability and any other HMRC liabilities properly identified, we can move through that liquidation process quite speedily.
Just lastly, if a company is wound up, is it possible to reuse the company name again in a regulated financial service as well?
I think there's two answers to that. The first answer is, if we look at a solvent liquidation and the company's been sort of dealt with properly, it's gone into liquidation, it's then been dissolved, that name is then available. There was no issues with it, the company was solvent, directors are free to use it. If there's an insolvent liquidation, the insolvency legislation itself states that a director cannot use the same company name, a similar company name or trading style for a period of 5 years from the date of liquidation. If they do so, it's a criminal offence, and in the new limited company, they're not protected from limited liability.
Interesting.
Now, there are ways around that. For instance, if you already have a limited company with a similar trading name that has been trading for at least 12 months prior to the liquidation, not dormant trading, then you're exempt from that restriction. You can also purchase the goodwill off of the liquidator. There's some hoops you have to jump through. There's an advert that has to be placed in the London Gazette.
Good old
our friend,
Gazette.
yes. And then you have to write to all the old creditors of the company in liquidation, advising that the new company does, advising that it's bought the goodwill and X is likely to be a director of that particular company. And again, then they have met the criteria to be exempt from that restriction. And finally, they can make an application to court. So under insolvency legislation, it is possible for a director to use a name once the company has gone into an insolvency process. You then have, of course, the FCA. And the FCA is very concerned about phoenixism, and rightly so, and ensuring or wanting to ensure that the clients are not harmed and there is not turmoil in the market, and they do expect insolvency practitioners to really prevent phoenixism where it is not appropriate to do so.
Well, that's certainly enlightened me and given me a lot more understanding of that process. But I know for sure now that if somebody asks me that question, I'll be coming to give them the correct answer on that.
Yes. It's outside of the FCA. It is a very dangerous situation for a director to reuse a company name in an insolvent company, and what you don't want is that criminal offence. I mean, the risk of personal liability in the second limited company. It's a very dangerous situation.
So Glyn, we know it's unacceptable, certainly under fit and properness under financial services, to deliberately close down a company to avoid paying creditors and setting up a new company, and sort of phoenixing assets to do so. But for some businesses, we're aware that they're looking to de-risk that business by closing old co and creating new co. Are there situations when that is perfectly acceptable?
Phoenixism. To define what it is, it's basically where, or the practice of an old firm which has liabilities, closing, and then the directors and potentially assets reappearing in a new company, and effectively all the liabilities have been left behind in that old company. Now, under UK law, the directors of that previous firm can be directors of any other limited company unless they've been disqualified or made bankrupt. So there's going to be a period of time when actually they can do that. And if there has been loss to clients, complaints with the financial ombudsman, then the FCA are very much against that. And they do expect the insolvency practitioner to highlight any areas where they believe phoenixism has happened and to raise those concerns with them and notify them accordingly. So I think the answer to your question is that if there is a director out there whose business is insolvent and they are looking to put it into a formal insolvency process, they do need proper advice. They do need to seek the views of the FCA as well and make sure whatever they're doing, they do fully transparent, and really have got to see whether the FCA are going to be prepared to tolerate them as a fit and proper person going forward. And if they try and cut corners, that's when they could be causing themselves a significant issue.
Subscribe to our YouTube channel and switch on post notifications so that you won't miss our next video in this series when we discuss market conditions faced by company owners that are looking to exit and liquidate, and an insight into M&A situations by two industry experts, me, Gary Venner, CEO of one of the UK's largest specialist brokers in IFA acquisitions, and Glyn Mummery, insolvency practitioner and partner of national business advisory firm FRP Advisory, who are a leading national business advisory firm.